The next speaker is Miss Karuna Sharma, Civil Judge Junior Division cum-Faculty member. Miss Karuna Sharma joined Haryana Judicial Services on 2nd December 2013 and has to her credit the rare distinction of having been selected as additional district and sessions judge on 22nd December 2018. She passed her master's in law from Delhi University in 2006. She has also practiced in district courts in Delhi as well as the Delhi High Court for more than 7 years. During this period, she also acquired rich experience of teaching law in Law Center 1 Delhi. She joined the assignment of faculty member at Chandigarh Judicial Academy in the year 2020. Now I request Ms. Karuna Sharma to throw light on the topic, the Criminal Procedure Identification Act 2022. Over to Ms. Karuna Sharma.
Thank you, ma'am.
कैच कर लें।
मैं कहीं छोड़ रही हूँ।
हाँ जी।
मुझे स्क्रीन में देखना है, इनको देखना। A very good afternoon to all of you. So today I will be speaking on Criminal Procedure Identification Act 2022. इसमें बात जा रही है?
आपकी आवाज इधर से जाएगी, उनको तो सुन रहा है।
So today's topic is the Criminal Procedure Identification Act 2022. Now, we all are aware that in our day-to-day working in a criminal court, we keep getting these applications for obtaining the signature of the accused because it has to be matched with his signature on some of the documents if it is a case of 420 or in any other case. We also get applications for getting the voice samples, for getting the fingerprints and the handwritings also from time to time. So this is the act which deals with the measurements of the accused and the other persons and gives us the power as a magistrate to obtain these. Now I'll take you to this PPT. Now we have to know that before this act came in the year 2022, there was another act which was Identification of Prisoners Act 1920. This Act of 2020, so I'll be, for the sake of convenience, I'll be denoting this as an Act of 2022, the new Act, and the earlier Act is an Act of 1920. So the Act of 2022, it received the assent of the President on 18 April 2022 and it repealed the Identification of Prisoners Act 1920. As you can see that this was an act which was framed at the time when Britishers were there in the year 1920. So there was so many lacuna. We are going to look into these facts that why there was a need to have a new act and so where were the lackings which were there and how they have been plugged in this new act. And then we will also look into the fact that whether this new Act 2022 is sufficiently taking care of the various lacunas that there were in the previous Act. Now, there's a saving clause whenever there's a repealing Act, so it has a saving clause. So section 10(2) of the Prisoners Act 2022, it talks about it basically saves any act done or any proceeding taken or purported to have been taken when the previous act was in force. So any such act will be protected by virtue of this saving clause, which is contained in section 10(2) of the Prisoners Act 2022. Now, if you can see in the slide, there's a mention of this case in the second paragraph, which is Ram Babu Mishra versus State of UP. In this case, it was felt because this was a case wherein an application was filed for obtaining the signatures, specimen signatures of a person, of an accused, and the magistrate, because looking at all the provisions, it was found that there is no specific provision for obtaining the specimen signatures and writings of the accused by a court. Even if you talk about section 73 of the Indian Evidence Act, which gives unlimited power, so it was said that that section is only dealing with cases when the case is with the court, means the trial is going in the court. So that is for the purposes of the court proceeding and not for the purposes of investigation. So it was felt that the Act of 1920 was not sufficient to take care of the different problems which have been arising, because earlier it was very simple that cases of rioting were there. So people can be identified just by taking their photographs, just by taking their fingerprints. But now with the advancement of the technology, there is different ways and means in which the offences are now being committed. And so with the modern technological advancement, we have to take care of the fact that even those things are to be taken into account. So on the basis of this, 87th report of Law Commission. So in this case, Rambabu Mishra, it was felt that as such there is no provision which is there, and so it was also in the last paragraph of this judgment, it was said by the Honorable Supreme Court that there should be some suitable legislation. There should be some suitable legislation which should be dealing with this particular thing, which should cope up with the changes which are there. Then in the 87th report of Law Commission of India, this was on the Identification of Prisoners Act 1920, and again in this it was discussed that why there is a need for bringing the change in the legislation, and also this case was referred, and then it was felt that there should be some legislation which should balance the interest of both the parties, interest of the accused and interest of the individual. Then there's a comparative study which has been done in the because that will help us to understand why this act has been brought into force and why what changes which are there which has been made in this act. Now, if you see the preamble, so from the preamble we always get to know what is the purpose of the act which has brought into force. Now, if you see the preamble of the Act of 1920, it is very simple. It says this is an act to authorize the taking of measurements and photographs of convicts and others. So it is very simple. And if in the next slide we will see what is the meaning of term measurements and what all is included in this term measurements. So it had a very limited scope. So measurements, I'll take you to the next slide just to give this view. Now you can see in this slide, it talks about section 2A, wherein of the Act of 1920, there's a single line which says measurements include finger impressions and footprint impressions. So these are the only two things which were included in the Act, right? Finger impression and footprint impression. And in the preamble, you can see in the Act of 1920, it also says that photographs of the convicts can be taken. So you have to remember there are three things: the footprint impression, what else? Fingerprint and the photographs. So there were three things which were there. However, now it is, as you can see in the preamble, it says act to authorize for taking measurements of convicts and other persons for the purposes of identification and investigation in criminal matters and to preserve record. Now this is something new, as you can see in the preamble, and to preserve record. There is nothing of such sort mentioned in the preamble, and as such there was no provision in the previous act regarding preserving the records. Fine, you are well aware we have NCRB, National Crime Record Bureau, which is empowered to record, keep a record of these things, because this may help once the measurement of an accused is taken, and if you have to crack another case, then you can obviously obtain the same measurement from without taking the measurement from the accused. You can also use the recorded measurement which are already there with the bureau. So that is the purpose for preserving records. Then matters connected therewith and incidental thereto. So it has been left open for interpretation. Now this was regarding the preamble. Then extent and commencement. So yes, definition. you can see that it specifically defines magistrate, because magistrate is empowered to obtain the pass an order regarding obtaining of the measurements. So in relation to metropolitan area, it is the metropolitan magistrate. In relation to any other area, the judicial magistrate of the first class, or in relation to ordering someone to give security for his good behavior or maintaining peace, even the executive magistrate is empowered. So there was no such definition previously in the Identification of Prisoners Act 2020. Now coming to measurements, because we all know that though this act was not there and the previous act was not amended, but we had so many amendments in the Criminal Procedure Act in the various sections wherein all these things were included from time to time. We all know 53 May Amendment hui, section 53A was amended, was added. So these have been from time to time included in the various provisions of the criminal procedure. But then we had no specific legislation, and the legislation we had was outdated. So now the amendments are there, a specific legislation has been made. So now it is said that the measurement in which previously included only finger impression and foot impression, now it will include finger impressions, palm print impressions, footprint impressions, photographs, iris and retina scan, physical, biological samples and their analysis, behavioral attributes including signatures, handwriting or any other examination referred to in section 53 or section 53A of the Code of Criminal Procedure Act 1973. Now you can see that what all is included in section 53 and 53A. 53 applies to 53A as well as 54. So it says what can be taken. Examination shall include examination of blood, blood stains, semen, swab in case of sexual offences, sputum, sweat, hair samples, fingernail clipping. So these are all now included within the definition of measurement, which was previously not there. Right? So this is one difference. Then who can take the measurement? This is another important question. Like, because we are ordering that measurement can be taken as a magistrate, we will pass an order on an application. So we have to also provide that who is empowered, who can take because police officer is going to take these measurements. So who is the police officer? What is the police officer's rank which should be there, who is empowered to take? So if again we see the difference between the previous act and the present act, in the Act of 1920, the police officer for the purposes of this act could not be below the rank of sub-inspector. Right? But now this rank has been reduced to the rank of head constable, meaning thereby that wider powers have been given. If you are reducing the rank of the person who can obtain, so you are giving the powers to the executive. Right? Similarly, in 1920, there was as such no provision for taking of measurement of either the convicted person or the non-convicted person by the prison officer. But now, if the person is in prison, even the prison officer, who means an officer of prison not below the rank of head warden, can be asked to obtain the measurements. Previously, there was no such provision. Then a very important question, who may be asked to give measurements? So previously, if we see, it says section 3 says every person who has been convicted of any offence punishable with rigorous imprisonment for a term of 1 year or upwards. So there was a rider. Not everybody who has been arrested or who has been convicted or who is suspected can be made to give his measurement. It will only be a convicted person, and convicted person who is convicted of an offence with punishable with rigorous imprisonment for a term of 1 year or upwards, or of any offence which would render him liable to enhanced punishment on a subsequent conviction. So there are few cases in which there can be enhanced punishment. So only in those cases. So there were limited cases, and that too only for a convicted person. However, now the categories, there are more categories. The first one being of convicted person, but convicted, as you can see in section 3A, it is convicted of any offence punishable, under any law for the time being in force. So the rider of 1 year punishment, rigorous punishment, that has been done away with, or enhanced punishment, that has been done away with. So if a person has been convicted of an offence punishable under any law for the time being in force, his measurements can be taken. Or any person ordered to give security for his good behavior or maintaining peace under section 117 of the Code of Criminal Procedure, or for a proceeding under section 107, 108, 9 or 10 of the said code. So in this case, as you have seen initially, that who will be empowered? The executive magistrate will be empowered. Then arrested in connection with an offence punishable under any law for the time being in force. So even the arrestee have been included. Then any person who is detained under preventive detention law, even he may be asked to give his measurements. Then what is the mode and manner of obtaining measurement? Again, this is a very important question, which is that can the accused, convict or arrestee be compelled to give their measurement? Can they be compelled to give their measurement? So the answer is contained in section 3 itself. It says yes. However, he can be obligated, he can be forced only in cases of offence committed against women, against child, or offences punishable with imprisonment for a period not less than 7 years. So in this case, these cases, he can be compelled to give his measurement. In other offences, he may not be obliged. So this is the important thing which has to be taken care of. And section 5 gives the power of the magistrate to obtain measurement. Now this is a wider power which says if the magistrate is satisfied that the purpose of any investigation or proceeding under the Code of Criminal Procedure or any other law for the time being in force, it is expedient to direct any person to give measurements under this act. The magistrate may make an order to that effect, and in that case, a person to whom the order relates shall allow the measurements to be taken in conformity with such directions. This is the general power. Now, previously, if you see this section 5 of the Act of 1920, so there were again certain riders which were that no order shall be made directing any person to be photographed except by a magistrate of the first class. So there was a rider on this power that if you are going to obtain the photograph of any person, then it has to be done only by, the order can only be passed by the magistrate of the first class. Secondly, there was the rider that provided further that no order shall be made under this section unless the person has at some time been arrested in connection with such investigation or proceeding. So if it is not the case of a person who has previously been arrested or has been investigated, then you cannot obtain. But now, even if he is a suspect, then his measurements can be obtained. Now, regarding resistance refusal, we know that in section 53 or section 54 also it is provided that reasonable force may be used in case he is not allowing himself to be examined. The accused is not allowing himself to be examined, right? Similarly, here also section 6 subsection 2 clarifies that any resistance to or refusal to allow the taking of measurement under this act shall be deemed to be an offence under section 186 IPC. There was similar law previously also, that it was made punishable under section 186 IPC, and 186 IPC prescribes punishment for a term which may extend up to 3 months or with fine which may extend to ₹500 or with both in case where offender have voluntarily obstructed any public servant in the discharge of his public functions. So this is discharging of the public function. If once there is an order by the magistrate and the police officer is following that order, then the accused cannot say that I am not going to allow my measurements. Then reasonable force can be used, and if he still resists, it is punishable under section 186 IPC. Now here we have to understand that there is a difference between testimonial compulsion, whether it is a testimonial compulsion or not, and then we have to see whether this act which is there, which is saying that force can be used, whether it is validated as per the constitutional provision of Article 20 Clause 3 or not, whether it is amounting to testimonial compulsion or not, right? So we, after going through, because I have a very limited slot, so I'm not going into the details of the cases which are there. You must have read Selvi versus State of Haryana. You must have read, be aware of K. Puttaswamy, wherein the right of privacy has been talked about and when such right of privacy can be infringed. So we have to see, we have to basically balance the competing interest of the society at large and of the accused. So we have to see the interest of both the persons and family have to balance it. So this is basically not amounting to testimonial compulsion because the accused is not speaking anything. In Selvi versus State of Haryana, you know that it was relating to narco analysis test and all the scientific tests which were there. So then it was There were certain guidelines which were laid down. There were certain parameters which were laid down that in what cases this can be done and in what cases this cannot be done, and when the consent of the accused will be important or not. So considering the nature of the test which were to be conducted on the accused, जैसे नार्को एनालिसिस टेस्ट है या लाई डिटेक्टर टेस्ट है या इस तरीके का कोई भी है जिसमें when you have to interfere with the body of the person by giving him certain medication या कुछ sedative उसको देना पड़ेगा so that he is gone through that inhibition and then he speaks whatever is being asked from her or him. So you have to, when you are interfering with the body of somebody, then definitely you have to take the permission of that person whether he wants to undergo that narco analysis test or other test or not. But if you are just asking a person to give his specimen signature, do you think you need to take the permission of that person? Because you are not going to do anything which is hazardous to him. You are not going to take any testimonial compulsion. He's not going to speak against his own interest. He's just giving his signature. He's just giving his the handwriting or anything, any of these tests which can be performed on him. So this is the protection which is granted under the Act, which is there. Section 7 Act of the Act protects any person against doing anything or intended to be done in good faith under this Act or any rule made thereunder. The power to make rules lies with the central government or the state government. So they will now this power which was there, now in exercise of this power, the specific rules have also been framed. Now we have the criminal procedure identification rules also which have been framed and which have been enforced in the month of September 2022. Now this is again very important that who is going to keep the record of the data or the measurement. So it is the National Crime Record Bureau, which is the authorized agency to maintain the record. They will collect the record, they will store and preserve the record, they will process the record, and they will also disseminate the record as and when the application will be moved before them, giving the information that why this record is required. Previously, there was no such provision because there was no provision of maintaining the record under the previous Act. Now this is again very interesting that for how long the record is to be maintained. So it says it has to be maintained for a period of 75 years, which is again very long time. Right? When any person who has not been previously convicted, and then there are exceptions when it can be discarded before 75 years. So when any person who has not been previously convicted of any offence punishable under any law with imprisonment for a term has had his measurements taken according to the provisions of this Act, is released without trial or discharged or acquitted by the court. In such cases, the court can pass an order for destroying the records of that person if he has been discharged, if he has been released without trial, or he has been acquitted by the court and there is no previous conviction or previously he has been charged with any offence. After all such legal remedies have been exhausted, so we have to take care of this because we have to give him a time to file an appeal also. The state, agar hum acquit kare to obviously the state is going to file an appeal, so we have to wait till that time. In such cases, all records of measurement shall be destroyed from the record unless the court or area magistrate for reason to be recorded in writing otherwise directs. So this bar of the suit we have already talked of. This is a comparative chart. We have already discussed everything which is provided here. Now this was evaluating the present Act on the touchstone of the fundamental right, that is right against self-incrimination. You must all be knowing what is Article 20 Clause 3 about. You also know about Selvi versus State of Haryana. We know about State of Kali versus State of Bombay versus Kathi Kalu, which is a very important judgment. So this was what was held in the Selvi versus State of Karnataka, that it was ordered that no test could be permitted without the consent of the accused. These are talking about the narco analysis test and the other tests which were talked about there. To the consent, no test could be permitted without the consent of the accused. Consent to be obtained before the judicial magistrate in the presence of their lawyer. Further safeguard was a statement was laid down by holding that the statement made would have the status of a statement made to the police and not a confessional statement. Now this is again a very important provision where बहुत ही उन्होंने अच्छा मतलब ये कहा कि what will be the evidentiary value of this statement which will be recorded during these tests. So it will be equivalent to the statement made to the police. That means it will have to be proved in the court. So it will not amount to a confessional statement on the basis of which only the conviction will be made. So it has to be proved by other evidences also. So it will mainly have a corroborative effect. It was further directed that any such test would be conducted by an independent agency in the presence of lawyer and would be duly recorded, just to see that no hanky-panky is there. Case Puttaswamy, you all know that though it was dealing with the Aadhaar cards, but whatever was laid down in this regarding right to privacy is important, and this is relevant for our purpose also, because it laid down that whenever there is invasion of the right of privacy of an individual by the state, so it has to meet the threefold requirements. The law has to be legal, which postulates the existence of law. The need has to be there, which is defined in terms of a legitimate state aim. And proportionality, again, we have to see that what aim we are trying to achieve and what is a nexus between what we are trying to achieve and what we have laid down as a law. And the fourth requirement to this test was added by Justice S.K. Kaul, mandating procedural guarantees. Now this has to be ensured by us. We have to see that procedure is duly followed. Fine. So if the procedure is not duly followed, suppose we do not take the consent, then the entire proceeding will be vitiated, and so it cannot be relied upon. Now regarding voice sample, because again you have seen, if you have noticed that in the entire definition of measurement, there is no mention of voice sample. So again, there is a gray area which is there, that there is nothing mentioned regarding the voice sample. So we have Ritesh Sinha versus State of UP, which talks about this thing, and when we evaluate it on the parameter of whether it is a testimonial or compulsion or not, so we come to this conclusion that it is definitely not a testimonial compulsion when a person is asked to speak something. So he may not be asked to speak the same thing, because there may be cases of when you are connecting on phone, you are talking on phone, so you have to tally the voice which is there, and so the judge may not ask him to speak the same thing which he may not be comfortable with. तो वो कुछ और भी बोलता है. So experts are there, who can easily catch, even if the accused will try to manipulate. Even in that situation, the experts will catch that he is trying to manipulate the things, he is trying to manipulate the voice. Sometimes they may go to the dentist and ask him, मेरा दांत ही remove कर दो. तो हर चीज से हमारे बोलने में फर्क आता है. Fine. तो अगर हमारे बोलने में तब फर्क आए, then we can ask for a medical evidence also कि इसने कोई recently कोई कुछ ऐसा तो नहीं कराया जिससे कि इसके अंदर कोई change आ गया है. Fine. So we can take those safeguards and then see. Now loopholes, regarding loophole and shortcoming, that is for us to discuss. Like I said, 75 years is a long time, and then it is not specified. थोड़ा vague सा है. This act is little vague, in the sense that when it says that the measurement can be forcibly taken from a person who has committed an offence against a child or a woman, but it is not specifying what kind of specific offences. So theft may be committed against a man and theft may be committed against a woman. So do you think if a theft is committed against a woman, because it is an offence against a woman, so it will be covered under this, his measurements will be taken? And suppose his measurements are taken in one case and he is acquitted in that case, but he's declared a proclaimed offender in that case, and इस तरीके का कोई separate case चल गया 174A में. So whether his measurements will be stored or not stored, then so this is there are no. So these are the gray areas which are there in this act. So these are few illustrations which were called out that when the problem may arise. Like you can see, person W is found guilty of rash and negligent driving and fined for ₹1,000. So he may have his signature collected and stored in a central database for 75 years. This is a minor offence, as you have seen that they have removed the rider. They are saying for any offence committed under any law, if he has been convicted or acquitted or he has been arrested, even in that situation his measurement will be taken. So since he has been convicted and fined for ₹1,000, so his signature will be collected and stored in a database of 75 years. The act permits this. Then person X is arrested for an offence. He refuses to give his fingerprint. He's charged with preventing a public servant from performing his duty, and hence he's punished. Whatever he has done is punishable under Section 186 of the Indian Penal Code. His fingerprints are forcibly taken under both the cases because there are 2 cases now. He subsequently discharged from the original case. However, as he is guilty under Section 186 of the IPC in the second case, his fingerprints can be stored for 75 years. And then the biggest lacuna in this case is, we have no problem, you store our data, but we don't have any data protection law. So we don't know where and when our data is going to be misused. So this is the biggest problem. Then there are certain rules which have been, as I told you, that Criminal Procedure Identification Rules 2022 have also been notified in the month of September 2022. So if you go through this, there are certain improvements here in Section 3. Rules prevail करेंगे because rules की power दी गई, rules बनाए गए. So there are certain improvements. If you will go through these rules, you will find that थोड़ा बहुत इन्होंने deviation कर दिया है from the main act by way of giving more powers to more people, by introducing some exceptions, by introducing some riders. Fine, whether it is valid or not, its validity, if challenged, will be seen in the court of law. Then there is another argument which says that Bureau has been given wider role, though it was empowered. But then when it says that the Bureau will come up with the standard operating procedure, so it has basically delegated its power. So this has amounted to delegated legislation. So far as these rules were concerned, these rules were when made, they have to be put up before the legislature, and they have to, with the majority, they have to pass such bill, and then finally this rules will come. But there is no such provision for the standard operating procedure. So standard operating procedure, which will be the procedure which will be prescribed at how and these measurements will be taken, how they will be stored, how they will be disseminated, the entire thing has been left to the Bureau. So this is one criticism of these. This is all we have in this. Thank you so much. I think I finished it in time. Thank you for the patient hearing. Thank you all.